Hi folks, I'm Jeff Simkovic from Billings Legal, and I'm here to talk about employment law. And in the state of Montana, ladies and gentlemen, you have a protected right to your continued employment, and being fired or forced to quit a job may constitute a violation of that right under Montana's Wrongful Discharge from Employment Act. However, that's true only if certain conditions are met. First of all, folks, probationary employees are not covered by Montana's Wrongful Discharge Act. The period for which an employee is considered probationary varies from employer to employer, depending upon that employer's written policy. If your employer doesn't have a written policy, then Montana law states the probationary period lasts through the employee's first 6 months of employment. Until an employee passes their probationary period, they are considered at-will employees and may, with certain exceptions, be terminated for a good reason, a bad reason, or no reason at all. After the employee has passed their probationary period, however, Montana law only permits that employee to be terminated if there is a business justification for the termination. This is a fact-dependent question for which the answer is not always readily apparent. However, if the employer is motivated by something other than the bottom line of the company, it is more likely that the termination was not for good cause. Additionally, if the company maintains written policies that bear upon the termination, but fails to follow these policies when it terminates an employee, it likewise becomes more likely that the termination will be found to have violated the Wrongful Discharge Act. A wrongful discharge claim, folks, must be filed within 1 year of your last day of work, the day that you were terminated by your employer. You may also be limited in terms of what you can recover under the Wrongful Discharge Act, as the current statute only allows you to recover 4 years of your lost wages, and that's determined by comparing your income at the time of termination and the income you earn at your next and subsequent employment. The employee is also obligated to make reasonable efforts to obtain new employment, and you may hear referring to that as mitigating your damages. In addition to being subject to Montana's Wrongful Discharge Act, other states and federal statutes also bar an employer from violating an employee's civil rights or engaging in illegal discrimination, even if the employee is not terminated. The Montana Human Rights Bureau investigates claims of illegal discrimination in employment. However, the time limitations for which you may bring such claim are as short as 6 months. So it is important that you bring your claim as early as possible. Consulting with an attorney can help you determine the best course of action when you believe your rights have been violated based on the conditions of your employment or the termination from that employment. Thank you, ladies and gentlemen. If you call Billings Legal at 406-248-7000, I'll be glad to give you a free and confidential consultation.